Good evening. Thank you for joining us tonight. We're trying to count how many events we've done on Guantanamo since 2003, when we started doing this kind of panel. And I lost count at some point. I just couldn't remember. And then I asked myself the question, well, have they been different? And for the most part, we've gone over the same ground over and over again, no matter how many military commissions acts it has, no matter how many people they release, no matter how many times they push the trials from one venue to another. But this one's kind of different, and I'm excited about it. Tonight we're going to focus not on the structure of Guantanamo, not on which is better, federal courts or military commissions, not on the future of Guantanamo, although I will ask all the panelists before the night is over, what is the future of Guantanamo, just because I want to let you guys know. But tonight we're going to focus on just what kind of handicap the defense attorneys have had to labor under since the beginning of Guantanamo. And it's one of those stories that's relatively unknown, relatively untold, and when it is told, the reaction is, oh, those defense attorneys, they're just complaining. So we thought, encouraged, I have to say, by Rick Cannon, who I'll introduce in a moment, that it would be a good time to sort of, in a rather precise way, to go over what the impediments are for defense attorneys in trying to mount a case for a defendant in the military commission system. And for the most part, we'll be looking at the high-value detainees. Those detainees, like Khalid Sheikh Mohammed, the mastermind of 9/11, and Khalid al-Nashri, who is accused of the USS Cole bombing, just, what it means to represent somebody like that, and just how difficult it is forgetting about what the charges and the severity of the crime is. So I'm not going to say much more. Let's get started. And I'm going to let our panelists, I'll give you brief introductions, but people who, the lawyers who have worked at Guantanamo for the most part have been getting to know one another for the past, what is about to be 13 years. And they've created a kind of community among themselves. Some of them have defended individual terrorism defendants in federal court as well as in the military commission system. And I think that's one of the beauties of tonight, is that everybody here can talk about the absurdities of Guantanamo, to pick a word, within the context of knowing what they're up against anyway in the criminal justice system, which has its own problems for criminal defense attorneys. So our first panelist is going to be Rick Cannon, and I think you've probably read about Rick in the press. He's often quoted, and he has represented al-Nashri, but he also has a familiarity with a lot of the cases at Guantanamo and is often in the mix of lawyers trying to make decisions about what to do in terms of the defense they want to mount. And so Rick, we're going to start with you, and each one of our participants tonight has agreed to just isolate one piece of what just doesn't work inside Guantanamo, and then we'll have a discussion among them, and then there'll be Q&A for you. So, Rick, do you want to begin?
Thank you. I'm really, really happy to be here. I'm pleased that there's so many folks here, because one of the frustrations is that the press largely has lost interest in it. That's personally very frustrating to me. In analyzing this, I think there are 5 or 6 overarching problems, and we'll all be talking about that to one degree or another. But the things that make it so much more difficult to represent somebody in Guantanamo than in what I call the commissions of real court are the location, the lack of law, the military and the military bureaucracy, the procedures such as they are, and then the secrecy, just the overwhelming burden of the secrecy. And that creates a huge amount of weirdness that we'll all be talking about. And the one thing I want to say is that, if you sat down to design a system and said, I want to create a legal system, everything will move slowly. Inflation. You would design this. And that's one of the frustrations is the defense in large measure gets blamed for the delay, but the delays are caused by all of these situations. A piece I'd like to focus on for just a minute, and we'll all probably be talking about it to one degree or another, is the secrecy. Because the secrecy impacts all of us in some very, very peculiar ways. You know, one of the things you may have read about is that not only is most of what our clients tell us considered to be more classified than top secret, even his thoughts or memories of what happened to him in CIA custody is considered to be so classified that it can't be publicly discussed. And that creates a huge practical burden, because if hypothetically the client were to say, boy, you really need to see Joe Smith over at 42nd and Broadway. It's a technical matter. You really can't go to, say, Joe Smith and say, hey, the client says I should talk to you, because that's really classified. So you end up having a whole lot of sort of weird workarounds. And that kind of secrecy just impacts everything that we do. And you know, the final point I'll make, and then just in the interest of time, give you an example. Government's a couple of years ago filed a motion, and you know, I get an email, the government's filed this motion, it doesn't even have a name. So I call the lead military lawyer and I say, you know, what's this about? He says, well, it's secret, I can't tell you. Well, of course, I understand that, but can you give me a hint? He says, not only can I not give you a hint, but I'll bet you can't even guess. It's so strange. So we play sort of the legal equivalent of 20 questions. Is it about this? Well, no. Is it about that? No. And so finally, he said, well, okay. So my office is in Indianapolis. I had to go to, you know, make arrangements, fly to Washington, D.C., go to what's called a SCIF, a sort of secure room, to read a 6-page motion, discuss it with the other lawyers, and then fly home. All at taxpayer expense. And that kind of thing is just repeated over and over and over again. So.
I mean, one thing that's not talked about is the expense, not just at Guantanamo, which is estimated to be, what, $2.7 million per detainee per year by the Miami Herald's study, but what the military commissions are costing. And you had a number on that. What was the number you had today?
The last number I've heard is 150 million a year.
Yeah, I think that's right. So it's awfully, it's awfully expensive, something that you might want to talk about. Let's move on to Jason Wright. Jason Wright is new here. I've never had you here before, so welcome. And he's been in the news lately, as you might know, for literally having been, the nice way to say it is pushed out of the military commissions process, and I think that maybe I should leave the rest of that to you to discuss. I think it is one of the impediments to having a trial.
Well, thank you for being here, and thank you for your interest. And I guess I was one of those individuals who benefited from some part of that 150 million, but I no longer get that paycheck from the government. But my name is Jason Wright. I formerly was an active duty Army officer. Prior to 2011, I served for about 8 years in the U.S. Army, mainly in Germany and also in Iraq as a JAG, as a legal advisor. In 2011, I was assigned to represent Guantanamo Detainees for potential trial by military commission. And at that time, the military commissions were on a bit of a hiatus. We can talk about that later, perhaps, in the Q&A. But needless to say, in 2012, one of my clients, Sheikh Mohammed, is going to be tried by the military commission. The structure of the military commissions is for the 9/11 case and also for the al-Nashri case, they're death penalty cases. And what that means is that death is supposed to be different. You're supposed to have greater reliability on the standards because of the finality of a conviction and death sentence. So Congress, in designing the system, said that there needs to be learning counsel for these men, people who have experience in death penalty jurisprudence. officers. And we have before us here, we have Mr. Kim and Mr. Harrington, who both serve as learning counsel. Well, they also have military counsel as well, detailed military counsel according to the statute. And we're basically public defenders in the military. I've done that in Germany for about 2 years, working on behalf of soldiers for the courts martial. So when I arrived in August of 2011 to the military commissions, I was shortly assigned to Mr. Mohammed's defense team. I, over the next 3 years, spent a lot of time in Guantanamo Bay, about 230 days, building a client rapport, and then later arguing on behalf of Mr. Mohammed at the military commissions. I participated in every pre-trial session, managed his capital defense team, and basically sat second chair in the litigation. Well, I was fortunate enough to be promoted to major in August of 2013. And when you're promoted to major in the U.S. Army JAG Corps, at some point you're supposed to get an advanced degree in military law. It's a regular academic course that you take in Charlottesville, Virginia, and there is no limit to the number of deferrals or deferral requests that you can put in. And you can request a deferral for operational or personal reasons. So if you're deployed, say, and come out on a list to attend a course from August to May of the next year, you submit a packet and say, I can't go because I'm deployed. Well, according to prior practice, this goes up to the Judge Advocate General for the Army. I have to add that there are several Army officers involved in the case. I was the Army officer detailed with Mr. Mohammed at Table 1 for the defense. General Martins is the Army officer for the prosecution at Table 1 for the prosecution. And Judge Pohl is the Army Colonel, who's the judge. So it came out on the list last year, and I submitted my request for a deferral because I was representing a capital defendant in a capital case. This depth is different. The Supreme Court recognizes that you do not pull a defense counsel from a case in active litigation. It's just fundamentally unfair. So my deferral was granted. I did not have to go to the graduate course. Well, I came out on the list again to go to the graduate course, and as the Army officer, I submitted my deferral request. Well, in February of this year, I was informed without explanation that my deferral request had been denied. I asked for a reason why, and I was told, well, there isn't a reason why. The Judge Advocate General of the Army had decided that simply that she did not want you to continue on the case and that you had to go to the graduate school to begin in August of this year. So I was given a choice. Do I voluntarily accept the orders and go to the graduate course, or do I refuse the orders? And I think 9 out of 10 defense attorneys would believe and agree with me that you have an ethical obligation to represent your client, no matter what. And that obligation is greater than your employer. So on that basis, I declined the orders to attend the graduate program, and under Army policy, when you decline orders, you're forced to resign. The resignation took 6 months to go into effect, and as of August 26th of this year, I converted from major to Mr. Back into civilian life. So that's essentially an access to counsel issue, and during the Q&A, we can pick up on something that Rick Campbell has also talked about in terms of secrecy. And a lot of other features to access to counsel issues. This is one of them. But also, in my situation, also presents an equality or inequality of arms principle. Shortly after I left, we learned that the same individual, the Judge Advocate General of the Army, who denied my deferral request, agreed to extend the Chief Prosecutor, the Army General, for another 3 years on the case.
So I just want to ask you one question. Was there any discussion of this? I mean, did you ever get into a discussion with the authorities on this, or was it just simply a matter of paper filing, paper pushing?
I asked for an explanation. Whenever a government agency gives you an adverse decision, you're entitled under the Administrative Procedure Act to know the reason why. And I was told that you'll never know why. You're not entitled to know why. Best of luck to you.
So it's kind of like with the defendants. You know, when you make a list of how much can be secret, this also can be secret. Okay, well, that's a little upsetting. So I want to turn now, we're going to have a discussion among all of them, which is why we're having these brief introductory remarks. I want to turn now to James Harrington, kind of a legend in the business, who I'm so happy to meet, seriously. And, but the reasons are, interesting, which is that in addition to his Guantanamo work, he's known for being the defense attorney for the Lackawanna Six. The Lackawanna Six was one of the first supposed terrorism cells that were tried right after 9/11, and became a big case that the government and others pointed to in terms of understanding what would be the nature of these cases, how they would play out. And so now he works with military commissions, and his client is Ramsey Ben Al-Shid, who I'm sure you've heard the name of, but after Khalid Sheikh Mohammed, maybe the name you hear most often associated with the high-value detainees and people that are waiting to be prosecuted. And has been somebody that the United States government has been paying attention to for a very long time. And so we're interested in hearing what you think are the major impediments to getting there.
What I'd like to do is to mention just a couple of examples. Some of you may know them, but we had a number of really bizarre things that happened in proceedings. One is that when they made this courtroom, we have big long tables and they have microphones on the tables. There's 4 microphones on each table. And when we were told that if you were going to speak to your client or speak to each other, the lawyers, you should press the mute button because the microphones were on all the time. And we were also told that even though you press the mute button, that the court reporters would be able to hear part of it and somebody else might be able to hear part of it, but don't worry about it, they won't do anything with it. And so we complained vigorously about that, and they told us that if the complaints went on, well, really, your microphone is not the only thing that's picking you up because these two microphones that they work together and they have a force field so that the microphone 2 or 3 down might be able to pick you up also, even though it's not good. So the judge responded to that by reversing it. He said, okay, the microphones are off all the time now unless you press down on it. And we had some arguments about this, and we asked for the schematics of how the microphones were installed, and they produced schematics, but they weren't up-to-date schematics. For some reason, they couldn't find the up-to-date ones. And so, obviously, it raises a certain level of skepticism, but we plowed on. The judge seemed to think that his role in this was remedying a problem. He remedied it, so don't complain about it. And then we had a situation where one of the lawyers got up and he said something which wasn't really classified, but somebody thought it was. And what happens in the courtroom when somebody says something that should be in a closed or classified proceeding, and it's a public proceeding, there's a court security officer that sits next to the judge, and he pushes a button, and in front of him is a red light that is exactly like a hockey goal light. And it flashes around, and the screen comes down in front of the visitors in the back, and everything shuts down. And so one of the lawyers made a comment, which turns out it was not classified, but the hockey light goes off, and the judge looks at the court security officer, and he goes like this, I didn't do it. And so we wonder who hit the button. Well, it turns out there's an outside agency that had access to this. We were told no one else did have access to it. And so the judge expressed extreme indignation that day and stopped the proceedings, and we came back in the morning and with the assurance that no third party would have access to the hockey light or the classification and decision and everything else. But the judge's demeanor was totally changed. Okay, I remedied the problem, let's move on. And so then we find out that in the places where we visit our client, which is not where they're housed, they bring them to a separate place. They have these huts, they're literally huts where we go in and we meet with our clients, and they had smoke detectors in the ceiling, and it just seemed kind of an odd place to have a smoke detector. It's a room that's 10 feet wide by 15 feet long.
Since no one can smoke there.
Right. Or have access to anything that would ignite anything. So we kept questioning, and the guard said, yeah, they're smoke detectors. Well, and it turns out they weren't smoke detectors. They were listening devices. And so then they told us, well, they're only listening devices that were used when the FBI interrogated somebody. Not sure, guys, but when they interrogate somebody or somebody's cooperating. But don't worry, even for that, we never let them listen to your conversations, and it can't be recorded. It can only be listened to. So the judge directed that we had to be able to see the court control room. And we go in and look at the control room, and you're looking at all these devices and things that they have there, and you see a thing that says Rewind. So, okay, so they take out the smoke detectors. And the reason I bring it up is not just the fact that it happened, but it's the judge's response to this. I mean, I have said publicly that I cannot imagine a federal judge who would let somebody, anybody, interfere with his or her domain, which is the courtroom, that he or she did not know about and did not sanction it or approve it. And there's no indignation on the part of the court, first of all, but worse than that, we are cut off from finding out who was doing it or why it was doing it because the judge said we're moving ahead prospectively. The last thing I want to talk about is something that happened to my team, and back in near the end of last year, one of the investigators on my team felt that another person on my team, an interpreter, may have been violating the security laws by passing information from our client to people that it shouldn't be passed on to, namely his family and Anna. And when we first started these proceedings, everything our client said was classified. And even the commission judge said that's just nonsense. Our client would tell us things that he wanted to pass on to his family, like his grandson or his nephew was starting school and he wanted to pass a message on. And so we allowed those messages to go on. And one of the people on our team thought that there was something wrong with it. And the FBI started an investigation. And we were not told that this person had cooperated with the FBI, was working with the FBI. And he was allowed to stay on our team quietly for another 6 months. And this only surfaced because the FBI, in their infinite wisdom, sent 2 agents to another member of our team. And like FBI School 101, you go at a time when the person is most vulnerable. So they go to this man who's very religious. They go to him at 3 o'clock in the afternoon when he comes home with his wife and kids from church. And he's a security officer. He helps us determine what things are classified. So he's got a lot to risk if his security clearance is taken away from him. His livelihood is taken away from him. And they come in and they get him to talk to him, and he signs 2 agreements that he won't tell us or anybody else what it is that they have done or what he's doing, and that he will work with them in the future. So now they want another person working inside a defense team. And they say, well, it's strictly to determine whether there's violations of federal law. And no one is saying that they don't have a right to investigate crimes or potential crimes that are happening. But you don't invade the defense function like that. So we've lost our interpreter as a result of this. We now have a proceeding pending in the court, which has helped to stop our case. Our case, we have done nothing for a year. Nothing. First, they said that my client needed a competency hearing. That took 6 months to resolve. With no competency hearing, nothing being done. It was just abandoned. Now we have an issue about a conflict of interest. Do I or any other members of our team have a conflict of interest? Because we're worried that the FBI, the Department of Defense, or somebody else is investigating us personally for either crimes or our security clearance or some other administrative thing, ethical violations. And would we put our own interest above our clients in order to defend ourselves? Is there a conflict of interest? So they had to appoint a new lawyer for our client so that lawyer can advise separately our client what his rights are, whether if there is a conflict or potential conflict, he should waive it. The hearings were canceled in October because this is not resolved. We're supposed to go back in December. It won't be resolved in December. And just to put the frosting on the cake, we don't know. We surmise what it is that the violations were. But all of the documents that have been filed with the court about these issues have been filed under seal. And we have not seen them. So I have an ethical obligation to go to my client and say, here's what the problem is, Ramsey. I'm telling you that I can still represent you. This doesn't bother me. You can accept that or reject it. But that's my obligation to tell him that, or tell him that I can't represent him. The conflict counsel has an obligation to go to him and say, this is what the problem is for Jim. He's told you this. You have a decision to make this way or that way. Do you have any questions? Here are the options that you have, and you make your own decision. Right? The problem is, I can't tell Ramsey what it is that I'm afraid of or not afraid of, or that may influence my decision. And his conflict counsel cannot tell him what it is that I might be afraid of. So how we get out of that box, I don't know. But that is supposed to come up again in December, and our projection is that we will go down in December, we will walk into the courtroom, we will spend half an hour or an hour talking about this, and the judge will then suspend the hearings until February. So that,
So once again, whatever the specific is, secrecy has a lot to do with, or withholding information, or whatever you want to say it. Also, I mean, I think your point about being surveilled, whether it's by somebody inside, reporting on you, or mechanisms in the walls, or whatever it is, it has to be a rather uncomfortable feeling for you and your client, I would think.
just one quick
Yeah.
anecdote. Our client has a better attitude about it than we do. They knows everything anyway. They're listening.
Yeah, great. Well, now we're going to turn to Martha Rayner. Martha is a professor here. She's a clinical professor. She runs the International Justice Center. They do many things, ranging from Guantanamo detainee issues all the way to Occupy Wall Street, to many other interesting things. And she's going to talk about something a little different. So let me just put this into perspective for you, which is that right now at Guantanamo there are 149 detainees in custody. 80 of them have been cleared for release, but are still there waiting to be resettled or returned home, or whatever happens with them. Another 36 have been put in a category which is basically labeled forever detainees or indefinite detainees, and they will be detained indefinitely. This was a policy that was fundamental to the Bush administration, and that President Obama was willing to support about 5 months, starting about 5 months into his presidency. And so, as a counterpart to the good news that you might be tried, there's bad news that you might not be either charged or released. And Martha's going to talk a little bit about the other detainees at Guantanamo and that, occupying that space as well.
Great, thank you, and thank you all for being here. Right, so my impediment in representing clients at Guantanamo is that I can't get them charged. I actually would like the government, military prosecutors, to bring on some charges. I'm going to tell you why. So, as Karen just said, right, my clients are not called prisoners, they're called detainees. They're supposedly in non-punitive detention. They're not being punished, they're being detained as a preventative measure. And so their imprisonment is completely indefinite, and it may never end. So when I compare their situation to that of a substantial set of men who have been charged, tried, convicted, and punished through the military commission system, and I'm not referring to the clients of the panel members here, but to still a substantial number of people, I look at that and I say, I want that treatment for my victims. And when I compare the unproven claims against my clients to the facts that have been proven against a set of men who have already been punished, they're not so different. In fact, one could say that the allegations against my clients pale in comparison to those who have been already convicted through the military system. So why do I want my clients to receive that treatment? Well, because they've either been released from Guantanamo, or they know they will one day be released from Guantanamo. And for the men who have been released, they've gone home, they've been repatriated. And for the men who haven't been released yet, they know one day they will get out. That's not true of my clients. So despite the fact that they haven't been charged, they haven't been convicted, and they supposedly haven't been punished, right? They really could very well spend the rest of their lives in Guantanamo. So let me give you an example, right? So Jason mentioned for a moment sort of the different iterations of this commission system. And during its first iteration, right, a man named Salim Hamdan was tried by the military commission. One of the 5 Guantanamo Supreme Court cases is named in his behalf, which took on the legality of the first iteration of the military commission system. But Mr. Hamdan, right, came out pretty well from the whole process in the end. He was actually convicted after a trial of providing material support for terrorism. He was given a sentence of 5.5 years. He was given credit for the time he'd already served at Guantanamo, and he went home a few months later. Okay, and by all reports, Mr. Hamdan is doing quite well in Yemen, and there's often some press attention about him because people tend to be interested in what he's up to. As Karen said, right, compare him, right, to the 88 Yemenis who are held at Guantanamo, 58 of whom have already been cleared, right? They've been approved to go home, and yet they still languish, right? And so, no Yemenis have gone home in 5 years since 2009. But Mr. Hamdan, charged, convicted, punished, he's home. He went home in 2008. Another example, David Hicks, the Australian. You may have heard of him, those of you who follow the Guantanamo world, right? He was also convicted of providing material support for terrorism. He was sentenced to 7 years. Most of that was suspended. He went home. He's a free man walking around Australia. Omar Khadr, the poor soul who was grabbed by the U.S. military when he was 15 years old, right? He was had a very, very tortured history at Guantanamo. He was accused of killing a U.S. soldier. Right? He ended up pleading guilty to murder in violation of the laws of war. He ended up being sentenced to 8 years. He served another year at Guantanamo. He's now been sent back to Canada, where he is still incarcerated, but he has a definite release date. Omar Khadr will see the light of day one day. So, I'm not saying, right, that any of these men were treated justly or fairly. But what I know is that they are doing a lot better than my clients, right? And so, even though the U.S. government says my clients are not being punished, right, that their form of incarceration is different than what happened to those men, right? I think for my clients, they feel the sting of punishment just as much as those men who eventually went home affected, right? And so, in my view, I say bring on punishment, right? We'll take it, because in comparison to what they're facing now, they will do much better. But right, the military commissioning system, because it is so hobbled and it is so troubled, right, and there are so many of these problems that you're hearing about, right, we can't begin to really engage in that kind of work, which is really appropriately what it should be doing.
Just one thing, one word you didn't use to distinguish between those who have been cleared for release and are still there, and those who have been labeled forever detainees, is the idea of hopelessness, and what that actually means to be in a hopeless state. So the hunger strikes that we're reading about have been associated in the press, particularly because of this one detainee, with those who have been cleared for release but have not been released. What about hunger strikes and those in your population that you deal with? Is this a theme? Is this an issue? Do you know?
Well, sure. I mean, for men, there's just no end in sight, right? There doesn't seem to be an avenue to release, right? Because it all hinges on detention until the end of hostilities, right? Which is, when will that be, right? Will that be when the U.S. withdraws from Afghanistan, right? The Obama administration is already saying no. Right? The Obama administration is already saying that the conflict with ISIS, right, is a conflict that may qualify as a continuation of the conflict with Al-Qaeda, right? So there will be no end of hostilities that I can foresee. And so for the men, right, they have engaged in hunger strikes. They've engaged in peaceful protests to try to bring attention to their plight. And it is a very significant fight. And I think actually there was a mass hunger strike in the winter and spring of 2013. It was actually quite effective. It brought quite a bit of attention back to Guantanamo, and it brought the Obama administration. It brought Obama's attention to this issue, which he had ignored for many years. But once again, right, we've now, it feels as though, once again, the Obama administration has turned away from the issue. And I don't think that, I appreciate, I don't administration pay attention to this issue.
Our last panelist is Michelle Paradis, who graduated from Fordham Law School. That's not the only reason he's here, but that's one of the reasons we're proud of him. And Michelle is on the front lines in terms of basically the appellate lawyer arguing these cases. He works in the Defense Counsel's Office for the Military Commissions, and he's done it for almost 8 years. So it's been a long, slow, arduous process. One thing I want to say is somebody someday should write about Guantanamo defense attorneys and the psychology of what happens year after year. Because as an outsider who's had to watch this, I have to say that it's like hitting your head against a wall over and over again, and yet you guys, with the exception of Jason, continue to do it. But you have forced. No, I know that, and I see it, and we can get to that. But one of the things Michelle's had to do is to articulate the legal and constitutional principles that override these cases and undergird these cases. And last week, he argued the most recent iteration of the Al-Balul case, somebody who's been convicted, whose charges are up in the air again, who convicted and sentenced to life, but whose case still goes on and on. It's kind of the opposite of Hamdan. Michelle's going to talk to us a little bit about what it means to be brought in to the military system when you're not used to it, and what it looks like. And this is an issue that has hounded the Guantanamo military commissions since before they were called military commissions. Michelle.
Sure. And I'm happy to talk about a lot of the exotic legal questions, because I think those are as much a burden on the defense counsel as any of the practical considerations we've talked to. And on a given day, and I'll just say this succinctly, is that on a given day, we actually don't know what the law is on any question. If you go into a federal court, you argue from the law of your circuit. If you go into a state court, you will argue state law. If you go into an international court or a military court, you argue the law of the forum. There is no such law for the military commissions. And so literally every legal issue, every single legal issue that's confronted is a question of first impression. And it's a bewildering problem, particularly for lawyers, American lawyers who depend on some common law analysis. We're common law lawyers. We argue from precedent. We argue from analogy. And how you can do that when there is no law is an enormously challenging question that interacts in a just paralyzing way to the problem I wanted to mainly focus on tonight, which is that, regardless of what you think about the human rights problems in Guantanamo, regardless of what you think about the rule of law problems in Guantanamo or the military commissions, or generally, the Department of Defense, and that's the department I work for, so I say this with a little bit of hesitation, but the Department of Defense is just not up to the job. And I distinguish the Department of Defense from our military. We do have, and anyone who's interacted with foreign militaries and our own military, we have the most amazing fighting force the world has ever known. We have unquestionably the world's most professional, the world's most efficient, powerful military. The Department of Defense is an organization, depending on how you count, of more than 3.2 million people distributed around the world with varying political objectives, with various interest groups that they have to cater to, and that all conspires together in Guantanamo and in the military commissions in particular to create a situation where no one knows not just what the law is, but who's in charge on a given day over a given question. And as I was sitting here, I started to think, and I just tried to write down as many, what we call in the government, stakeholders, but as many governmental institutions who have some role in the military commissions in Guantanamo. And I'm going to read this list off. J2 for the Joint Task Force Guantanamo, the Joint Detention Group, the Joint Intelligence Group, the Convening Authority, the Trial Judiciary, the Combat Support Group, the Office of the Chief Prosecutor, the Office of the Chief Defense Counsel, Southcom, the Joint Medical Group, an entirely separate bureaucracy for Camp 7, which holds the former CIA detainees, the Department of State, the Central Intelligence Agency, the FBI, the Department of Justice National Security Division, the Department of Justice Solicitor General's Office, the Army, the Navy, the U.S. Marine Corps, the Air Force, foreign country nationals, so Filipino and Jamaicans who do the staffing, who are sort of the permanent residents of Guantanamo, as well as various independent contractors from various independent contracting firms, such as Bremcor, such as, and they cover everything from our different contractors, entirely different organizations who do our contracting for logistics, IT, linguistics, so translation, construction, and travel. And those are just what I could think of sitting up here. And so you have a lot of different people with a lot of different interests, all operating at the same time. No one person, other than perhaps Barack Obama, being in charge of any of this. And to just sort of give you a sense about how the military operates organizationally, is the military is organized for combat. It's organized for foreign deployment. And a big aspect of the military culture, the military professional culture, is that you don't do any one job for very long. In the military, if you are a lawyer, like Jason was, it's very unusual to be in a particular legal office somewhere in the military, be it in Okinawa or be it in Fort Bragg. You're only going to have that job from 1 to at most 3 years. And then the expectation, if you want to proceed along with your career, and often by obligation, you are required to rotate into an entirely new job that you've never done before. And the rationale, arguably, behind this is so that everyone in the military is able to do every job. Now, the old expression is there's a jack of all trades and a master of none. And when it comes to administering complex international criminal cases that are at literally the bleeding edge of our legal system, that type of organizational structure grinds to a halt. Because not only is everyone's rotating at different times. And so that every single time you go down to Guantanamo, which can typically only be about once a month, because there's only flights typically every other week, maybe every week, and you have to stay down there for a week. So you go down there for a week, and everything you do is different. How you get your badge to get into the courtroom is different. How you get your badge to go into the detention facility, which is a different badge because it's owned by one of these different stakeholders, is different. And every single time you go to Guantanamo, you spend about a day, a full working day, simply getting the keys to your office or the badges you need to get to where you're going, to get a car so you can drive around this base where you don't have, you can't drive yourself down to Guantanamo. To get the keys to your lodging and making sure that the lodging that you have, which is always being turned over day after day. And it's this constant churn, and it's the interaction of this intense churning at every level of responsibility. That is why, regardless of what you think about the human rights consequences, regardless of what you think about the rule of law consequences of these military commissions will never work. And if they do, it will only be because we've cut such remarkable corners in haste to make up for all of the time we've lost, that we've foregone anything that resembles a criminal trial, certainly in the United States. And so people wonder why, and we take the brunt of this, why it's taking so long. The defense lawyers are taking so long. The defense lawyers are delaying these cases. We are moving as fast as possible. And it is simply that the system itself, the gears are so enormous and so decentralized, with so few people with a long-term stake or operational control over anything that's happening, that on a given day, you just can only do so much, even on top of these very, what I would sort of call the deliberate obstacles to having us be able to do what an ordinary lawyer would do. And the last thing I would say, just because I think it's important to remember, is that we have not only the world's best fighting force, we have one of the most robust criminal justice systems in the world in terms of its efficiency, and certainly in terms of the sentences you can get, in terms of the solidity of convictions that are procured in federal courts. The rate of success on appeal in a federal court is phenomenally low. It's vanishingly small. If you've lost being prosecuted in a federal court, you've lost. And it's only it's only when you hit the lottery that something is going to happen on appeal to change that judgment. In the military commissions, so far of the 2 convictions that have gone up on appeal, Hamdan's, which was vacated outright, and my client's Al-Balul's, which was vacated outright in 2013, the government sought reconsideration. 2 out of the 3 charges were reaffirmed in terms of getting them thrown out. And 1 is outstanding, and we argued that one last week. And that one, again, will just be, given the nature of the legal process, we'll probably wait until another 6 months, maybe a year, before we have any finality in Balul's case. But at a minimum, it's up in the air. And I would say, from a criminal defendant standpoint, Balul is in a better position than any federal defendant I've ever seen in terms of winning his case on appeal. And the basic reason is we've asked our military, which is designed to fight wars efficiently and spectacularly well abroad, to do what our federal court system does. And the military generally just, this isn't their job, and the Department of Defense is not designed to do what our federal court system does.
So I have a question for all of you. Martha, I'll give you a little different twist on it. And that has to do with, when you talk about the frustrations of evidence, the amount of secrecy, the incredible concern the government has for what goes on between client and attorney, which is sort of amazing within the American system. And you wonder, why are they using Guantanamo? Why do we have another military commission system under Obama? Thought that was over with Bush, et cetera, et cetera. How much of this is really about just making sure that the treatment of detainees, particularly the high-value detainees that were tortured in CIA black sites, how much of this is really about that? And how much is about something else that maybe can rise to the surface?
I think our case is the furthest along, so let me start this.
When you say our case,
In
just
the Sherry case. In my opinion, everything about Guantanamo is designed, and Guantanamo exists to keep the public from knowing the full extent of what the CIA did in the black sites. Period, no new paragraph. If that becomes public, which it is very unlikely to, there would be really no reason for Guantanamo to exist. Virtually all the restrictions we operate under are designed to protect CIA information. It's so closely held that even though all of the lawyers have top secret SCI, what's called SAP clearances, we're cleared to see this material, the government takes the position that even we can't be trusted with it, and so they want to give summaries of this information. And let me give you an example of sort of the summaries. If the relevant facts were that on October the 28th, Rick Cameron went to Chicago to make a presentation at the Loyola Law School. He spent the night he made 2 presentations. He spent the night in Chicago. The next morning he flew to New York. He met with some people in New York on the Mashiri case, and then made a presentation at Fordham Law School. Let's say that was the fact, and that's what the CIA document would show if you could see the original document. The summary would probably read something like this. On a day in the 4th quarter of 2014, Rick Cameron left his home and went from one place to another place, and then he went on to a 3rd place, and then he returned. Literally, that's how general the summaries are, and so the goal of all of this is to sanitize what was happening in the black states. And that's the goal of it. We all have these anecdotes of secrecy that make us crazy, but let me give you the final example. Early on, won't get into the weeds on this, but the government filed a motion dealing with something that was secret and dealing with these substitutions. And we were ordered to respond to the motion. The problem was we were not allowed to see the motion or even know what it was about. And so when we filed a motion to say, essentially, Judge, can you get us in the ballpark? Is it about the RDI program? Is it about the coal? Is it about some other stuff that in the case was classified? The response was not no. It was basically hell no. How could you bother to ask this? So we had the obligation to file a response to, and it was very important, pleading, because the judge can't reconsider his decision once he makes it. We had to file a response to a motion that we had never seen and had no idea what it was about. And that, to me, just sums up Guantanamo.
Did you file it?
Yeah. We took a guess. I mean, we basically filed a 50-page motion with 3,000 pages of attachment and said, we're making a guess here, so this is what we think.
Jason, let me ask you for a little bit of a twist on this, because with ASM as a client, there are two issues that go on, and the chief prosecutor, Mark Martin, tried to sort of combine that. And one is his saying that they're not going to let evidence that was coerced or tortured out of a defendant or a witness into the trial. But the other is, and the other side of it, and this is what the defense gets tagged with, is not wanting you to bring it up as defense attorneys in the courtroom. So can you, does that make everything come to a standstill? Is there a way around that, or how does that affect your brief episode?
Well, this touches on something that Rick mentioned earlier in the evening, and that when we first started these cases several years ago, the government told us that anything that came out of our clients' mouths were considered to be presumptively classified at the top secret level. Now, this phrase, presumptive classification, is something that had never existed before in the laws of the United States. We have U.S. intelligence law, we have executive orders that outlines it. So I go in for my security clearance briefing. Now, this time I arrived and I had a top secret security clearance, but I had to get access to the special program, and so I received a PowerPoint brief, much like all things in the military. And I had a briefer who told me that when you meet with your high-value detainee, you have to treat everything that he says as presumptively classified. Every word, every utterance, every gesture. I said, hypothetically, well, what if he told me he liked peanut butter sandwiches? Is that classified? Yes. So we fought in litigation before the military judge this concept of presumptive classification. He said it's illegal. You can't do that. This is Kafka. What government in the world believes that it can actually classify someone's thoughts and beliefs? And what they're classifying were the words that would come out of their mouth about their torture experiences. Which, in a sense, in a death penalty case, we can't forget that. This is a death penalty case, which is mitigating evidence. Evidence that goes to the very heart of the defense case. And that evidence is being restricted by the government. The judge did actually decide that the presumptive classification regime was unlawful, but nonetheless he decided to side with the other stakeholders, and Michelle, thank you for raising those, with the intelligence community, which said that, well, even though this concept of presumptive classification no longer exists, you still can't talk about the who, what, why, when, where, and how of torture. So that's a framework that currently exists on us. Additionally, we also cannot share any information with the defendants about their guilt that may be classified. So imagine yourselves being in a different country, being tried in a different language, where there's a new law that was designed to try you. You've been subjected to abuse for several years. You have attorneys who show up and say, hi, I'm here from the government and I'm here to help you. Never mind the military uniform. Your mail is read, your communications with your lawyers are read, there's listening devices in your cells, there's listening devices in the courtroom. Oh, and by the way, the evidence that we're going to use against you, you can't see. So that's the Guantanamo experience. If I can just add one additional thing, if I can, and this is almost the overarching concept about the military commissions. Justice Jackson at Nuremberg was asked the question by the Russians and by the Soviets at the time, well, why don't we just go out and kill them? Justice Jackson said, well, we can't do that. If in fact there is an acquittal then these trials have to mean something. It means that if a Nazi war criminal were found not guilty, they get to be released. Well, this has been challenged before the Military Commission, and the U.S. government continues to maintain that even if they're an acquittal, leave aside the so-called high-value detainees, even if they're acquittal for Marcus Klein, the U.S. government has said they still have the authority to detain them. This is the classic definition of a show trial, is when the outcome of the trial has no meaning whatsoever. And that's ultimately what we're dealing with in Guantanamo Bay.
So that makes it's a two-pronged thing. One is the reason we have this, what you call, Kafkaesque process is actually about torture. But the second thing is that the acquittal issue, which torture would bring and could bring in the courts, means that the federal system really can't be used, and from the point of view of the people in charge. So that's it's sort of a two-pronged thing. I want to turn to the two gentlemen here quickly, and just one of the things that the government is constantly saying is, look, these are national security secrets. We can't divulge national security secrets. What you collectively say is that these national security secrets are how the CIA treated the people in custody that we're trying to try, and the ways we obtained our evidence. But are there some national security secrets that are other than this? Are there other things that you think the government is trying to keep quiet about, plans and strategies and the structure of Al-Qaeda? I mean, that is a possibility, or do you think it's too far from 9/11 for that to be the case, or they've been in Guantanamo too long for them to have information? I mean, there must be something there, or at least I'm asking the question, must there be something else there, and have you stumbled across it?
I think in terms of looking at the torture, there's two aspects to this information. One is about the torture itself, and the other is about the information that was given up under torture. And if the information given up under torture talks about Al-Qaeda's structure, talks about plans to do things and the rest of it, I don't have any problem with classifying that. We don't care about that. That's not the issue. The issue is about, for us, is about the torture. And why is that being kept secret? It's being kept secret to protect people. Whether it's the people who engaged in the torture, many of whom were assured by their government that if they did these things, no one would ever know, and they would never be prosecuted. It's being done to protect people going up to the President of the United States that allowed it to happen. There can be no other reason. I mean, you talk to any American, even now, with all the things that have been said about it, and this has never been exposed, it's never going to be exposed to you. Some of it may be exposed to us in this trial, but you're not going to hear that, because that's all going to be done in a classified setting, and we're going to be told we can't go out and tell you about it or tell anything that happened. But Americans still believe that we don't do these things. Right? And I mean, and that's the problem. That it's not just that Americans, I'm sure Americans have done it at the beginning of this country, because it's human nature to do that kind of thing when you're really angry and you're in a situation like that, but we've never tolerated it before. This is an official toleration of it, and I think there's a real neurotic response by our country here and by the people in the country. We want to believe in our country. We want to believe still that this is the shining light on the hill. This is a real black hood put over the light, and we all struggle with it. And you listen to say, well, this is different because of the number of people that were killed and how horrendous this was, and we didn't deserve this. Without getting into reasons why this happened or it didn't happen, it's as Justice Jackson said, it's the ideal case to show that we are different, that we are the light on the hill, and we're not the light right now. And even if we did all these horrendous things and did these things that were wrong, the beginning of purging ourselves of it is exposing it. I'm not here even advocating punishment for George Bush or Dick Cheney or anybody else. I don't care. I don't care about that. And I don't care about the people who actually did it. But I think that it needs to be exposed, and my problem is that it's never going.
Yeah, I think, because I would have asked the same question too, is that, well, aren't you just lumping, there's a lot of national security information, this is just one, and I think the reason I know that that's just not true is that we do get national security information. So we get information, a lot of information, non-trivial amount, we get is classified. It is classified top secret, and I can tell you we've gotten things that are much more recent and operational relating to our cases. Things that, these actually really are important national security pieces of how our national security infrastructure operates as of a couple of years ago. That stuff is given to us virtually unredacted. And it's only when all of a sudden we start getting into torture that happened 12 years ago in faraway places, that all of a sudden we start getting the summaries that, like the kind Rick described, something happened and it was late, or something happened and it was cold. And you have a certain, and that's what's bewildering. And the only thing I would add to what Jim said is even when you read some of these summaries, as anodyne as they are and as they are made to be, there's a lot of stuff in there that is extremely top secret, but that is way worse than you would have thought. We've heard a lot about waterboarding. We've heard a lot about anything else if you've read the CIA IG report. I know there's a big fight now in Congress over releasing the Intelligence Committee report on torture. That's been going on now for like 18 months. But there is, I can understand why people wouldn't want this to come, even the thin little bit we've been given, why you wouldn't want that to come to light if you were responsible for it.
Martha, does the torture issue come up with your clients?
Absolutely. And
Or?
right, so one of my clients was also in a CIA secret site. And it's incredibly disturbing sitting across the table from someone who describes to you what your government did to them, and then they hide it. And this is chilling. This stuff is really quite chilling. The government won't even allow me to look at these records, right? I have top secret records, right? They've entrusted me, and yet this is, they've told me you will never get this. Right? And I'm not talking about getting it to disclose it to the public, right? Or get it to disclose it even to my client, which I would be prohibited from doing. They won't even let me see it, right? So all you can think, God, what's in there, right? What's in there that they have worked so hard for so many years to hide from me? That's true.
So we're going to take some questions. Let me just say that we have about, of course.
Two things, anecdotes that somebody told me when I first started in this, which have proved to be true, and I think apply to all of us. Guy who is in position to know said, look, if the government's telling you, or telling the public that your client was waterboarded and they threatened with mock execution, that's because that's what they're comfortable with you knowing. And the other thing he said is, think about it this way. We don't hide the things we're proud of. And that's what this is all about.
I want to add one other thing, because it's a logical question. You say, well, why don't you go talk to your clients and ask them what they did to you? And you have to understand how damaged our clients are as a result of what's been done. And we have to tread very carefully if we even broach these subjects. And when we do broach the subjects with our clients, they pay a price for it. They go back to their cells, a day later, 2 days later, something happens to it. We're not trained, prepared as much as we try to be in handling this kind of information. And our clients, in many cases, have repressed it.
All right, so make your questions very short. Bert, you're first.
Yeah, I've been working in a lot of these areas for decades, but the mind boggles listening. And so I've been thinking about what can be done. And I want to, with regard to what Mr. Harrington and others said, that we'll never know. the fact is that, well, probably everyone here in the media thinks that it's now up to the president and the CIA to decide what in the torture report can be made public. That's not true. It's up to Congress. When we created the intelligence committees, we put in a provision that said if a majority of the committee and of the Congress and of the full Senate votes to do it, they can make it public. It is not up to the president or the CIA. So that if anyone here contacts Congress, this may come out. My question is, has there been an article in the New Yorker, New York Review of Books, not about the treatment of the Guantanamo people, but about what we heard tonight? And if not, there should be an article, and then I think you could get a congressional hearing if you would be willing to talk about it.
Bert's trust in Congress is wonderful. And I would say we've waited on Congress for so long for this report, and I think they feel a little unempowered. They handed this over to the president. I'm not going to burden the rest of you with this. To the president.
They are empowered.
I know they are empowered, and I think it's a nice reminder. So I'm not going to take it as a question. I'm going to take it as a statement. So just talk without the microphone.
Yeah, I just want to clarify, actually, Karen, you said the discussion with attorneys, the torture is not even an issue on documents, say that. But given that is, are you saying on the panel that the torture reality of past, if the president, the attorney general had the will, and Congress would allow it, if we went back to where we were in 2009 and said bring KSM and the others to New York, bring the Cole trial, which is at the New York, are you saying as a panel that the torture reality of the past would preclude real trials and real convictions in federal court? And the second question for all of you, and maybe Jason can answer this quick. Karen called this panel Gideon's Army. Why are you guys doing this? The logistics and the legal hassles, especially, Jim and Rick, who do cases in federal court, why bother?
Let me answer first. These cases could be brought in federal court. I think the conventional wisdom is federal judges would be far more aggressive in ordering and less deferential to the government and would order the information produced. And I think that's my experience is that when a federal prosecutor says, we have this information, we don't want to give it to the defense, the judge says, well, you have a hard choice to make. You can dismiss your case or give it to the defense. And so I think that's the equation. The second question, because I know we're short on time, I'll just answer very briefly from my perspective, is this is what lawyers should be doing, at least in my view. If we can't stand up and oppose the government in cases like this, that's what American lawyers, I think, are supposed to do. And my view is, the short version, there's three audiences. There's the members, there's the international press. The U.S. press has largely lost interest. The world press has not. And then there's history, because these cases will be reviewed in history. 20, 10, 20, 30 years from now. And the question that will be asked is, were the lawyers doing what lawyers are supposed to be doing? Are they telling the truth? And I'm hopeful that when people look back on me, they'll say, yeah, that guy was in there and he was fighting and he was one of the people telling the truth.
I have a bit different take on the last part of Rick's thing, and that is something was mentioned before about the toll this may take on the lawyers and the mental health of the lawyers. I just think that the lawyers went into this mentally ill.
Please be loud.
Yeah, you guys had said, you mentioned, you referred to Kafka, and which I get the reference. It sounds a lot more like Joseph Heller, but I get that reference. But I heard you all talk that it's an unwinnable case, it's hopeless, it's banging your head against the wall. Even if we win, they're going to get detained anyway. And the criticism that you're laying on the government makes you all sound like very competent prosecutors. Have you ever decided or thought that maybe our energy is better spent putting this government system on trial and prosecuting them for the very things that they're depriving your defendants of?
No, I mean, I guess I'm not, at least I think I'm kind of where Jim is. Like, I've let go of the sort of any anger that I had in wanting to prosecute people, and I think at a certain point so I went to Fordham, and I was going to Fordham on September 11th, and I remember that, I think, as much as many of the people in this room do. And I think probably the reason that I do this job is that I know we are better than how we responded, and the legal system doesn't like any of the things we've talked about, and that's just evidenced by the fact that we're lawyers and doing these cases. And in some respects, we're the immune system for the American justice system. And we caught a disease after September 11th, which led us to torture, which led us to give up our values because of reasons that I think many people in this room, certainly if they lived in New York 13 years ago, would understand. And rising above that and trying to heal the legal system, if that doesn't sound too trite, I think does motivate me, at least, and I'm sure it motivates everyone at this table to want to just to return our justice system, as glorious and as amazing as it is, to being that shining city on a hill, that example, so that it used to be that when you went to a foreign country, the NGOs you talked to in places like Sierra Leone or Sudan would always be saying to their government, look how the Americans are doing it. They're so rich, they're so powerful, they respect human rights. Look how the Americans are doing it. And now if you go back to those same places, it's the government telling the NGOs, look how the Americans are doing it. They're detaining people without trial, they're using these military tribunals, they're using they're using torture. So what are you complaining about? And I think if we can show that that isn't America, I think we'll have done something.
Last question, Beth.
As a lawyer, I see this problem as not only limited to you. I see this the other day in court when a judge to me said, oh, I'm not surprised that a impartial hearing officer is handpicked by the prosecutor. So my question to the whole panel is, would it be better for you not to take part in the sham and as a group to say, with the secrecy requirements and these various aspects, this is a Kafkaesque proceeding and we're not going to be part of it? That's my question to the panel. And to Mr. Wright, as a recently retired JAG myself, reservist, there's a lot of good JAGs and a lot of bad JAGs, and I think the reserve has some really good ones. And there have been JAGs that have stuck up for the rule of law and opposing torture. And there are JAGs that are politicians, and I'm really sad to hear he is the victim of it. Sounds like our current JAG seems like a politician, but I would recommend that you maybe join the reserves.
So you can each make a quick final comment in response to that or anything else.
Well, let me just share with you an anecdote. When I was first approached initially by the ACLU about becoming involved, the military doesn't do death penalty cases. I've done quite a number of them with a lot of success. So the ACLU said, would you be interested in helping in that way? There was a lawyer who had been working on one of the cases, a fellow named Tom Fleener. You may have come across him. He's a Navy lawyer. And so Tom and I were speaking in the program together, and I asked him, should I get involved in this? And he said something that I thought was just humorous, but it's really true in a perverse way. He said, well, yeah, but you need to understand something. It's porn for lawyers. And he said, you're going to feel dirty being involved. You know you're enabling a corrupt system. It's kind of addicting because you're going to spend all your time thinking about it. You know you shouldn't be doing it, but you just can't help yourself. And here I am.
I don't quite know how to follow it. It's challenging, and I've had that question before, sir, about when is enough ultimately within the military commissions. But when it comes to capital defense, it's a great fear of ours that were we to abandon the clients, that the government would just appoint someone else who may not fight as zealously. And it's a paradox of our system. Congress created the Military Commissions Act of 2009. They said, do your job zealously. And we take that obligation very seriously in accordance with Supreme Court precedent to test the system, to make sure it's fair. So it's, there may come a time, and this is pre-trial litigation right now, where enough is enough. And I can't say that that's not a possibility. But for me personally, I do take some inspiration from what John Adams did back with the Boston Massacre. And for those of you who have read his book, or at least the most recent biography about him, he said that the greatest service he provided to his country was defending those men in the Boston Massacre. And I think many of us feel that way, at least in terms of trying to defend the rule of law. And we are fortunate, I was fortunate enough to do it in a military uniform, where I had the protection and the shield of being able to say it was my duty to do it, I was ordered to do it. But you know, defensive lawyers do that every day in the United States. It's not limited to just the Guantanamo cases. So if you're in court today, sir, for a criminal defendant, you know that as well as we do, that it's there to defend the system.
I think this loops back to what Michelle said before, that there is no standard or real rule of law here in the commissions, but what essentially we're trying to do is establish one. And it comes backwards because we're operating in this amorphous place, and eventually it goes up on appeal, and you hope that the appellate courts are going to say this is bad, or this is wrong, or this is the way that it should have been. And look at Michelle's case with Balul. Balul didn't contest his trial. He wouldn't let his lawyer argue or anything. He just lay down, and he wouldn't do anything. And now the case is on appeal, and 2/3 of it are gone, and maybe the other third is going to be gone because people like Michelle and some other people that he works with were willing to take it up and basically impose the rule of law. So I think that's part of the reason to do it.
Of course, if Mr. Balul ultimately prevails in his appeal, the military is going to move him from punitive detention to indefinite detention. So, you know, this is the banging your head against the wall, right? Because let's face it, right? I'm not in this, you know, about, you know, I'm in it to get my clients out. That's why I'm in, right? I'm a criminal defense attorney. I represent individuals. I got into this because the Center for Constitutional Rights, which coordinates the work of the habeas attorneys, put out a call for volunteer lawyers. And I figured, I know how to represent men who are locked up, right? I know a thing or two about habeas corpus. I can help. Well, I just jumped down a rabbit hole. Nothing to do with what I know to be the concept of criminal defense, right? But I think there is an incredibly important job of bearing witness, and we all talked about that, and that's what I'm going to continue to do. And at this point, I'm all my clients happy. That's it, right? And honestly, my ability to help them at this point is extremely constrained, right? Because the law, it's gone. There's no law, right? It's politics. Politics is hard. Politics of Guantanamo are extremely hard.
I think the only thing I would say, and picking up on what Jason said, is that John Adams, who defended the British in the case of the Boston Massacre in Boston, which was no small feat. But I think the thing that people forget, or at least overlook in telling that story, is that he also won the case, which was just as controversial, if not more, than taking up the representation. He didn't just stand there as a potted plant. And you know, it may not be the Al-Balul case for any number of reasons. It may not even be the Shiri case or even the September 11th case. But I do have potentially a naive but a lasting and abiding hope that by standing up and fighting to win for your clients, like Martha said, is that we will actually that the rule of law will eventually prevail, and we will.
One thing to point out in all of this that I don't want you to miss in all of the details is that the 9/11 case has still not been tried. And it's been 13 years. And there's no way to draw a direct line, this is my perception, but there's no way to draw a direct line between how a society gets over a trauma and how it moves on. But something deep in my gut tells me, and I think tells you, and I think this is why you also do it, that trying these individuals is the only moment after which we'll be able to move on. And so we look around and we say, why is nothing working? It's not working in part, and this is the sort of Mobius loop here, in part because we haven't had this trial. And it is crippling in sort of some psychological dynamic. Two things before you go. Monday, we're having a full-day conference starting with the director of the FBI. We've changed our space, so we now have room for all of those who we wrote to and said you can't come, so you can re-register online if you'd like that. The second thing is that everybody mentioned the Senate report that's going to come out. I think it is going to come out. I don't think it's going to come out before the election, but pay attention to it because you don't think it'll ever come out. Okay, it may never come out. Pay attention if it doesn't.
You know as much as I do, I'm just very cynical.
No, thank you for joining us and thank you.